So I'm going to introduce just sort of the background and the facts of the Google and Equustek case, and then take you guys through the Supreme Court decision, and then Justin's going to walk through sort of what happened next after the Supreme Court of Canada decision and the litigation that ensued after that. So what's the issue here? As most of you probably know at this point, the broad issue in the Equustek saga is the extent to which a Canadian court can order a third party to a litigation to take steps on a global basis. The underlying action in this case is an intellectual property dispute where Equustek alleged that DataLink was passing off a number of Equustek's products and then selling those products online. Google ends up fitting in because Equustek asks Google to de-index all of DataLink's websites so DataLink can't actually continue to pass off its products. The issue is all the DataLink's main players basically absconded from the Canadian jurisdiction. So when Equustek went ahead and got injunctive relief against DataLink, it couldn't really actually do anything about it. Equustek asked Google to de-index DataLink's websites. Sidebar, what's de-indexing? Basically, that just means that when you Google a keyword, for example, DataLink, a hit won't actually come up. Equustek gets a court order requiring Google to de-index its web pages, and Google goes ahead and does that for a number of its pages. The issue that arises is Google de-indexes pages for google.ca. So the issue is, as Justice Fenton noted, he's the judge that decided the lower court decision in this case, he said that it essentially amounted to a game of whack-a-mole. So as Google de-indexed DataLink pages, it could essentially just move its content to a different page. So for example, that would populate when you went to google.com or google.uk or another variation of Google's extensive network. So what to do? Equustek then decides to approach Google and try and get injunctive relief, requesting Google to de-index DataLink's pages on a global basis. So this wouldn't just be google.ca, it'd be google.com, google.uk, Google in France, everywhere that there's Google. So how does it go? Justice Fenton says sure. It grants the injunctive relief in favor of Equustek. The British Columbia Court of Appeal agrees, and then we're off to the Supreme Court. Oops. Is that bad? Okay, leaving that there. So the majority of the Supreme Court of Canada, in a 7-2 majority, basically rejects all of Google's main arguments. Now remember, Google's a third party to this entire underlying set of litigation. The underlying set of litigation is between DataLink and Equustek. So Google's a third party. First, Google's main argument says that, you know, we're a third party, we have nothing to do with this, and non-parties can't be the subject of an interlocutory injunction. The Supreme Court says, yes, it can. This is contrary to the jurisprudence. We do this all the time. We do this with Mariva injunctions. We do this with Norwich orders. To suggest otherwise really would be contrary to the jurisprudence. Second, where are we? Second, the Supreme Court says that it also grants extraterritorial orders all the time. To suggest otherwise would be contrary to the jurisprudence. They do it all the time to ensure the effectiveness of injunctive relief. Then third, although the Supreme Court does acknowledge that it's possible that international comedy concerns could be raised in this case, essentially this was too theoretical of an argument. So the Supreme Court said if Google went away and was actually able to provide some sort of concrete evidence that there were comedy concerns, that Google would be violating the laws of a different nation or a different state, then it could come back and it could always request, bring a motion or application to vary the underlying injunction. And this is actually the most important point because this is sort of, this is the underlying aspect that grounds all of the subsequent litigation that follows after the Supreme Court's decision. And Justin's going to talk more about that. Then lastly, the Supreme Court basically dodges the freedom of expression issue altogether, which is the main thing that everybody was, and I think still is, really most concerned about. Justice Abella said that basically in order to remove websites doesn't, on its face, engage freedom of expression values, which was a very interesting decision, particularly in the light of how the US court ended up approaching this issue, which transitions into what Justin would like to talk about.
Okay, thanks, Lindsay. So the Supreme Court is kind of phase one of this saga, but it continued after, because Google basically takes the Supreme Court up on its offer to provide a more compelling basis to engage evidence of comedy concerns, and it goes down to the U.S. District Court in Northern California and seeks an order that the injunction that the BC Supreme Court made and the Supreme Court upheld is unlawful and unenforceable in the United States. The proceedings in the U.S. District Court were unopposed. The Equustek parties were named, but they didn't actually show up or participate. And Google's ultimately successful. They get the final order they're seeking in late 2017. And why did they get this order? Well, the district court says that the Equustek order, the order by the BC Supreme Court, upheld by the Supreme Court of Canada, makes Google liable as a publisher or speaker of information on the data link websites, and that this is a violation of the Communications Decency Act in the United States. I'll pause here for a moment to note that that's actually not what the Supreme Court says. The Supreme Court goes out of its way to say that Google is not being held liable. It writes at paragraphs 52 to 53, Google is how Datalink has been able to continue harming Equustek in defiance of several court orders. This does not make Google liable for this harm. It does, however, make Google the determinative player in allowing the harm to occur. But in any event, the U.S. District Court also has broader concerns, including the fact that the order made by the BC Supreme Court undermines the policy goals of the Communications Decency Act, which is like a big deal piece of legislation in the U.S., especially in California. And it also threatens global free speech on the internet. And that's the direct quote from the district court judgment in the States. Finally, the district court says they don't need to address concerns about the First Amendment that Google had raised because it could already kind of decide the case on the narrower grounds of the Communications Decency Act. So, armed with this U.S. court order, you can predict what Google's next move is. They go back to the BC Supreme Court and bring a motion to vary the Equustek order, just as the Supreme Court had contemplated could be done, seeking at a minimum to have the U.S. excluded from that order now that they have evidence of what they perceive to be comedy concerns. In February, Equustek seeks an adjournment of that motion until the conclusion of the underlying trial and the underlying action, because although, as Lindsay said, many of the data link defendants have actually kind of absconded and gone rogue, there were a series of other defendants who actually were defending the case. So the trial was actually ongoing. So Equustek tried to get this hearing of the motion to vary adjourned until the end of trial, and the request for an adjournment was denied. And the motions judge in that case, not Justice Fenlon, who made the original order and actually subsequently got elevated to the BC Court of Appeal, but a different judge, Justice Sharma, was very sympathetic to Google's position. She wrote that the Equustek order does engage freedom of expression in the United States. That right is treated differently than it is in Canada, and comedy warrants that this court be very concerned if parties are going to insist on enforcement of a judgment which another jurisdiction has found is not in compliance with its own laws. In fact, that is exactly the situation referred to by the BC Court of Appeal and Supreme Court of Canada that would justify Google's application to vary the injunction. So Justice Sharma denies the adjournment, says this is a big deal, we need to have this motion to vary heard very soon, which it is. And the final well, the latest chapter in the saga, perhaps the final chapter, is the motion to vary. And the decision on that was just handed down a couple of days ago on April 16th. And somewhat surprisingly, to many followers of this case, myself included, Google was unsuccessful in getting its motion varied. Now, they raised a number of arguments in favor of variance. Don't have time to get into all those now. But the main argument, as you might expect, was we are now in a world where we have provided evidence of the comedy concerns the Supreme Court had talked about. We didn't have it then, we have it now. We have this US District Court judgment. And that argument failed because the BC Supreme Court, not the same judge who had decided the adjournment motion, but yet another judge, Justice Smith, adopted a very narrow reading of the Supreme Court's articulation of what was required to vary the order. And the magic words there is that the Supreme Court talked about evidence that the order would, quote, require Google to violate the laws of another jurisdiction, including interfering with freedom of expression. That's the kind of phrase from the Supreme Court judgment that was the focus of debate. Seizing on the first part of the language, the BC Supreme Court says that the US decision does not say that the Equustek order requires Google to violate US law. Even without the order, for example, Google would be free to de-index websites if they want. Nothing in the Communications Decency Act prevents Google from de-indexing. And what the Canadian order does, according to the BC Supreme Court's decision on the motion to vary, is it just restricts Google's choice in whether to de-index or not. So based on that kind of reading of things, they didn't see the threshold articulated by the Supreme Court for comedy concerns was met. Nor did they find that Google had demonstrated interference with First Amendment rights, which of course weren't addressed by the US District Court because of the finding on the Communications Decency Act. Very quickly, what can we take from these cases? What is clear? What's clear is that Equustek orders are available against non-parties. And when I say Equustek orders, I think it's safe to say that this goes beyond de-indexing. It can include blocking orders against ISPs, and I think it could also probably include orders that websites take down hyperlinks to sites that include unlawful content, that there could be extraterritorial orders, and that comedy arguments are going to need an evidentiary basis. What remains to be seen is how those principles are going to play out in a context either where Canadian freedom of expression concerns are implicated, because as Lindsay said, that was a total dodge in the Equustek case at the Supreme Court because they found on the facts that it was not engaged at all and offered no real guidance for what to do if it was engaged, or where foreign freedom of expression concerns are engaged. How far are we going to have to go to prove the type of comedy concern that the Supreme Court talked about in Equustek is actually a live one? Thank you for your time.